So thank you again for attending this first ever event, and we're going to get the show on the road now. So our first keynote speaker has traveled here today from Spokane, Washington, by way of Ecuador. Margil. Mari is the Associate Director of the Community Environmental Legal Defense Fund, where she leads the organization's International Center for the Rights of Nature. CELDF is a founding member of the Global Alliance for the Rights of Nature and assisted in drafting the Universal Declaration for the Rights of Mother Earth. Mari assisted Ecuador's Constituent Assembly to draft Rights of Nature constitutional provisions and is working in Nepal, India, Australia, and other countries to advance Rights of Nature frameworks. In 2016, Mari assisted members of the Ho-Chunk Nation in the United States to draft the first tribal constitutional amendment on the rights of nature and has advised members of the Green Party of England and Wales in developing their new party platform on the rights of nature. Mari has a master's degree in public policy and urban planning from Harvard University's John F. Kennedy School of Government. She is a co-author of several books, including The Public Health or the Bottom Line, and Exploring Wild Law, the Philosophy of Earth Jurisprudence. Today, Mari is going to speak with us about nature being invisible under the law. In the tradition of past people's movements, including the Abolitionists and the Suffragists, which organized to recognize rights of those treated as rightless under the law. Today, a grassroots movement is building to recognize legal rights of the environment, the Rights of Nature movement. So please welcome Margil.
Good morning. Good morning. Or should I say buenos dias? I'm just going to write down the time so I don't keep us too long. What time does that say? 9:40. It is really quite a pleasure to be here. It was a very long journey's day into night, I guess, as they say. And I just want to say very much a thank you to the staff and the volunteers, as Tish did with the Ohio Community Rights Network, my colleagues from the Community Environmental Legal Defense Fund, who worked very hard to bring this conference together. Now, as Tish said, I was invited to speak with you today about the growing movement for community rights and the rights of nature. And I understand, looking at all of the people here in the room, that we're here because we care about a wide range of issues. And I know some of us are here because we care very strongly about the environment or about public health, and perhaps are seeing toxic frack waste being dumped in our communities, frack wells being drilled through our aquifers, or perhaps Lake Erie being choked by algae and threatening drinking water. I know others are here because you're very passionate about achieving a living wage, or rights of workers, or are tired of seeing the corporatization of prisons for profit. And still others I know are here are simply tired of seeing their communities treated as sacrifice zones. And for big oil, for big ag, and other big industries, who will do most anything to prevent we, the people, from being able to actually decide what happens in our communities. They're seeing their democratic rights trampled not only by corporations, but by the very elected officials who are supposed to be representing them and their communities. Today, rather than thinking about these seemingly different issues, from the environment to public health to social justice, economic justice, worker justice, democratic justice, rather than thinking them as different, as Tish said, I'm here because I wanted to talk about how they are very much the same. For so long, it seems that we have these different concerns, these different issues that have split us into different voter categories, different organizations, different constituencies. We do our activism and we do our organizing targeting different people. And within our individual issue silos, we compete for members, we compete for supporters, and we compete for foundations, for dollars. So today, I want us all to think about how these different issues aren't so different at all, how they share common denominators, which I believe can unite us. So I wanted to start this morning by getting our brains going by thinking about some facts. Fact. Racism is intentional and was created and legitimized by those who benefited from it. Who? White men who derived wealth and power and influence by persuading the people of the colonial powers that enslaved people were inferior. They used fake science, as well as differences in culture, in language, in skin color, to prove this inferiority. As historian Ibram X. Kendi explains, they successfully advanced the notion that Africans were incapable of governing themselves, that in fact, they were better off enslaved rather than free. Kendi writes about John Calhoun, who hailed from the first slave state to secede from the Union, South Carolina. Calhoun served as a vice president and as a senator during the early part of the 1800s. Calhoun once declared on the floor of the U.S. Senate that slavery was, quote, unquote, a positive good. A positive good for society and a positive good for subordinate black people. He said slavery itself represented racial progress. So, fact, racism or racial discrimination is intentional and was created and legitimized by those who benefited from it. Next fact, gender discrimination is intentional and was created and legitimized by those who benefited from it. Who? Men who derived wealth and power by persuading society that women were inferior, were weaker, and needed to be governed by men. This resulted in women being denied the authority to own property, to have custody of their children, to keep the wages that they earned, and of course, to vote. In making their case, opponents to women's suffrage used arguments such as those put forth by California State Senator J.B. Sanford in 1911. Senator Sanford wrote, quote, "Woman is woman. She cannot unsex herself or change her sphere. Let her be content with her lot. Let the manly men and the womanly women defeat the suffrage amendment and keep woman where she belongs, in order that she may retain the respect of all mankind." Unquote. Fact. Gender discrimination is intentional and was created and legitimized by those who benefited from it. Fact. Discrimination against nature. Have you heard that idea before? Fact. Discrimination against nature is intentional and was created and legitimized by those who benefited from it. Who? Those who derived wealth and power through the wide-scale destruction of ecosystems and species. They persuaded people that nature was inferior, that animals were machines that couldn't feel emotion or pain, that nature needed people to govern it. As writer Charles Blacken explains, the big thinkers on this subject from the 19th century and earlier, quote, they believe, quote, that men must actively interfere with brute nature in order to maintain civilization. Nature, untouched by man, is a lesser nature. In the economy of nature is best when men actively superintend it. So today we have environmental laws which focus on things like forestry management and fisheries management. We still believe that we must control nature, that it must be governed. So fact. Discrimination against nature is intentional and was created and legitimized by those who benefited from it. Last fact. Discrimination against democracy. That is, against we the people having true democratic authority. Discrimination against democracy is intentional and was created and legitimized by those who benefited from it. At the Community Environmental Legal Defense Fund, we teach weekend workshops called democracy schools. For those of you here who have attended them, you probably think they'd be better named the "I thought I had democracy, but I don't" schools, because we look at how undemocratic our laws and governance actually are. For example, we look at the debates of the Constitutional Convention in Philadelphia, where the founding fathers, white men of wealth and property, were drafting a constitution that was touted as creating the greatest democracy on earth. In fact, convention delegates, of course, were having conversations that were anything but a celebration of democratic ideals. This includes the so-called architect of the Constitution, James Madison, who said that the Constitution ought, quote, to protect the minority of the opulent against the majority. And Alexander Hamilton, you know of Hamilton fame, he spoke favorably of kings and monarchy. He argued of the need to protect it against the, quote, extremes of democracy. It is this thinking that shaped the U.S. Constitution, resulting in an inherently undemocratic framework, which denied the right to vote, as well as other legal rights for the vast majority of the population that it governed. So yes, fact, discrimination against democracy is intentional and was created and legitimized by those who benefited from it. This discrimination against people, against nature, against democracy in our communities, it's all been intentional to advance the wealth and power of the few over the many. The community rights movement is built upon this understanding about how our system of law works and how it treats people, their communities, and the natural world. The Legal Defense Fund was set up to protect communities and their local environment, and we immediately ran into this system. We found that no matter if a community was facing a factory farm or coal mining or other threat, the law treated them the same way, legalizing these activities and preventing communities from saying no to them. So we had to understand why, which meant gaining an understanding of how the structure of law preempts us from deciding what happens in our communities, and how corporate rights are able to be wielded to override community decision-making, how laws ostensibly intended to protect the environment were instead legalizing the very harms communities were trying to stop. We learned, of course, that the law was developed intentionally to discriminate against democracy in order to advance the interests of the few over the many, which required preventing we, the people, from interfering with those interests. And they created a scaffolding to hold up this system of law. And it came in the form of legal doctrines such as preemption, whereby higher levels of government are able to override lower levels of government. And the doctrine of corporate rights, whereby corporations are able to interfere in our elections and our lawmaking and, of course, our communities. The community rights movement began as communities facing a wide range of environmental threats came to understand how this system of law works. Beginning with communities in rural Pennsylvania, who began to refuse to accept the fact that they couldn't decide what happened in their communities. They began to refuse to accept that they couldn't say no. No to activities that bring known harms to the environment, to their kids, to their families, and beginning nearly 2 decades ago, first in Pennsylvania, and then into New England, and then into the Rockies, and then into the Pacific Northwest, and here, right here in Ohio, this rebellion has grown. As more and more communities reject a system of law that does not recognize our authority to decide what happens in our hometown. So today, there are more than 200 communities across the United States that have enacted community rights laws. These laws establish certain rights, including rights to clean air, clean water, to a healthy environment, and the right to be free from activities that would violate those rights, such as factory farming and fracking. These laws establish the right to local community self-government, which means more than just being able to say no to things, but also importantly, the authority to say yes. Yes to sustainable agriculture. Yes to sustainable energy. Yes to establishing the sustainable, just communities that we both need and want. To do this, these communities have had to look at the fundamental building blocks of our governing structures, these laws and legal doctrines which were intentionally created to subordinate people, subordinate workers, subordinate communities, subordinate nature. So they've taken on preemption by higher levels of government, and they've taken on corporate rights and powers. They've taken on laws which regulate the use and exploitation of people and nature. Here in Ohio, this began in 2012 when the first communities in the state, like Yellow Springs and Broadview Heights, they mobilized and organized to adopt community rights laws, which assert their rights to clean air and clean water and their right to local self-governance. Shale gas drilling and fracking were banned in these local laws as violations of community rights. In 2013, Oberlin residents adopted a similar initiative by over 70% of the vote, followed by the city of Athens in 2014. Today, communities and counties across Ohio are engaged in community rights campaigns to protect themselves and local ecosystems from fracking pipelines and other threats. And this includes places like we saw in the video, like Youngstown, Toledo, right here in Columbus, Portage County, Meigs County, Williams County. And I'm wondering if folks who are involved in community rights campaigns here in Ohio might want to stand up so that we can see you. Stand up and applaud you. As more communities have come together, 5 years ago, you all joined together to launch the Ohio Community Rights Network, who of course is hosting us today. And as Ohio communities and counties have been supporting one another in their organizing, they've also been working to advance change to the state level. Tish mentioned the constitutional amendments that are being proposed and are here on petitions. They're collecting signatures now for those, and they would amend the Ohio Constitution, and there are 2 of them that are being proposed. The first, the Community Rights Initiative, would establish the right to local community self-government, authorizing people and their communities to expand environmental and other rights and protections at the local level, above those set at the state level, and take on those legal doctrines that deny us democratic rights. The second initiative, called the Initiative and Referendum Amendment, would, for the very first time, extend the right of direct democracy to all the people of Ohio. And as the community rights movement grows in Ohio and Pennsylvania, New Hampshire, Oregon, and other states, it's given birth to a new area of law. So I talked earlier about discrimination against race, discrimination against gender, discrimination against democracy, and discrimination against nature. At the Legal Defense Fund, we've worked with hundreds of communities across the United States to ban threats to the environment and advance community rights, these local laws, what we call community bills of rights. Those laws began to evolve. Beginning in 2006, we began to work with the first places in the United States, the very first places in the world, to advance legal rights of nature. So when we think about this, 100 years ago, John Muir, the American naturalist, he was thinking about this. He wrote that we must respect, quote, the rights of all the rest of creation. More recently, in a speech before the United Nations, Pope Francis, looking at climate change and other threats, he called for a new era of environmental protection. Pope Francis said, quote, a true right of the environment does exist. So to advance a new era in environmental protection means we must first understand our current era. That means, how are things working today? So much like we needed to gain an understanding of how the system of law discriminates against democracy, we needed to understand how it discriminates against nature. So we looked at the major environmental laws in the United States, such as the Clean Air Act and the Clean Water Act, which were passed now over 40 years ago and which have been mirrored in countries around the world. What we learned is that rather than protecting the rights of the environment, these laws instead regulate its use. So rather than protecting against fracking, environmental laws legalize fracking. Rather than protect against mining, environmental laws legalize mining. Rather than protect against water privatization, pesticides, pipelines, GMOs, and so on, environmental laws legalize those practices. Under this legal framework, the planet is suffering, and today we're living at a time of unprecedented species loss, climate change, ecosystem collapse. With species, we're experiencing what many are calling Earth's sixth great extinction, this time due to human activity. Species extinction today is accelerating between 1,000 and 10,000 times faster than natural background rates. Meanwhile, coral reefs are dying around the globe. The recent news of die-off across hundreds of kilometers of the Great Barrier Reef. This comes as studies show that coral reefs, which are a species themselves, that they provide habitat to upwards of 9 million species. But the oceans, of course, are warming and acidifying due to climate change and putting marine ecosystems, including the reefs and other species, at grave risk. And of course, with the climate, we now know that temperatures are rising far faster than even the most optimistic of scientific models predicted. 2015, 2016, 2017. Those are the hottest years on human record. But I guess this isn't news. What is new, and why we're here in this room, I believe, that there are growing numbers of people and communities and grassroots groups and even governments that are recognizing and acting on this knowledge. They're coming to understand that we cannot protect the environment under existing conventional environmental laws. Today, it's clear that we must make a fundamental shift in humankind's relationship with the natural world, because our laws, which discriminate against nature, are tearing holes in the very fabric of life. And to do this means that we need to change not only how we think about our place as part of nature, but change our basic structures of law which govern our behavior toward nature. In our view, that means we need to provide the highest legal protection on not only the human right to a healthy environment, but the rights of the environment itself. And of course, this will represent a dramatic transformation in how the law treats nature today. So today, environmental laws are premised on the legal doctrine that nature is property or an item of commerce. In the United States, our major environmental laws were passed by the U.S. Congress under the authority of the Commerce Clause of the Constitution. The Commerce Clause, by the way, is the same authority under which Congress passed the National Labor Relations Act and the major civil rights laws of the 1960s, treating workers and people as part of commerce. And in the same way, environmental laws treating species, waterways, and other ecosystems as commerce. So environmental laws in the United States and around the world, they regulate how we use that property or commerce. That is, they legalize the use or exploitation of nature. So under this construct, nature is considered to be without legal rights. That is, it is considered to be rightless under the law, as Tish said. And thus nature is effectively invisible in the law and is not seen or recognized by courts, much like women, slaves, and others have been invisible before the law. Recognizing legal rights of nature means transforming nature from being considered to be property to being rights-bearing. Indigenous peoples, slaves, women, all have been considered rightless under the law, and thus unable to defend their own basic rights to exist and to well-being. So today, do legal systems treat nature? Now, I know as many of you have experienced in your advocacy, we can spend years trying to fight a permit for a new pipeline or a new frack well, only to see those permits for those projects ultimately issued to corporations by our governments. In our organizing, we find that environmental laws and environmental agencies are focused on expanding fossil fuel extraction and other unsustainable industries rather than protecting us against such practices. Through our work at the Legal Defense Fund and with our partner community rights networks, we examine how, and more importantly, why systems of law work that way. Why inherently unsustainable practices are not only legal, but they're championed by government on behalf of industry, and further, why corporations have a right to frack and a right to mine. But nature doesn't have the right to not be fracked or the right not to be mined. So through our trainings and our organizings, including democracy schools, including the Ohio Community Rights Workshops, We examine the structure of law and governance. We look at the long history of colonization, of people and of nature, and the movements which have confronted these systems of law which legitimized and supported it. And we look at how today's legal system, aimed at constant, endless extraction, growth, production, development, rather than being broken, is in fact working exactly as intended. So understanding this in our work and in our organizing, we no longer try to regulate better, unsustainable practices such as fossil fuel extraction. We know that if we better regulate these practices, the earth is still being drilled, it's still being mined, it's still being cracked and poisoned, and fossil fuels are still being extracted, transported, and burned. To regulate something, of course, means to allow it to happen. People, communities, groups, tribal nations, and governments that we work with, they don't want these things to happen at all. They recognize that these activities are fundamentally incompatible with environmental protection. And they understand today that we're not coming even close to living sustainably on the earth. And so they find themselves in a position that is much like the position past movements were in. Much like the abolitionists, who couldn't protect the enslaved under a legal system which legalized slavery. Much like the suffragists, who couldn't protect women under a legal system which legalized their exploitation. And much like today, communities can't protect themselves under a system of law which legalizes their exploitation, forcing fracking and pipelines and other harms into our communities. Now, it took the building of broad-based people's movements to end slavery, to recognize women's rights, to change the system of law itself. And today we're working to advance systemic change by building a new people's movement for community rights and the rights of nature. So I know out there in the world there's a lot of talk about movements today. Turn on CNN and they're talking about movements. In our training and workshops, we examine past movements to learn the key lessons about what made them successful. So I wanted to talk for a moment today about movements. We know it takes movements of people to change the status quo, to recognize rights of those who are treated rightless under the law. The abolitionists, the suffragists, and others have had to build movements to challenge the dominant structure, both the culture and the legal frameworks, in order to change them. These movements have had to show how existing structures of law were illegitimate and unjust, or oppressive and destructive, and how they needed to change. And as we build a new people's movement for communities and nature, we must also demonstrate how the status quo itself is inherently destructive. That's how the existing system of environmental law that was based on treating nature as property was never intended to protect the environment. And further, how existing laws and legal doctrines such as corporate rights, such as preemption, are fundamentally incompatible with nature's rights. This history of people's movements in countries around the world show us that the kind of change, the fundamental change to our basic structures of law, begin and build upwards from the grassroots, mobilizing broad bases of people. And they recognized that what they were seeking was long-term systemic change. Thus, successful people's movements in history built and mobilized over decades. So looking at the suffragists, they built a movement that had to work for over 80 years to recognize rights of women. And they're still working today. The movement built up from the grassroots locally to the state level and ultimately to the national level to amend the U.S. Constitution. It took generations. The abolitionist movement similarly took generations, building upward for the grassroots to drive fundamental change in our constitutional framework, and of course, it's still working today. So today, how do we begin to move a movement for long-term structural change? It begins first by acknowledging that what has come up until now hasn't led to a sustainable relationship with humankind and nature. Part of this is recognizing that while many nations, not ours, but many, have recognized in their body of legal rights a human right to a healthy environment, the promise of that right remains unfulfilled, as it's become clear that fulfilling a human right to a healthy environment is dependent on the health of the environment itself. And further, it means we need to move from an anthropocentric view of the world to an ecocentric one in both our cultures and our laws, to recognize ourselves as part of nature as opposed to above nature. And this means transforming how the law treats nature by securing the highest protection for nature through the recognition of legal rights. This includes rights such as the right to exist, the right to thrive, the right to regenerate, the right to evolve, the right to restoration. Over 10 years ago, the Legal Defense Fund began assisting the first communities in the U.S. to develop these rights of nature laws. And today, dozens of communities in more than 10 states have enacted such laws. The first was the small community of Tamaqua Borough in Pennsylvania, and today, of course, includes communities in New Hampshire and Ohio and New York and other states. This comes as part of the community rights laws that communities in Ohio and other states are advancing, securing legal rights of nature and prohibiting certain practices, such as fracking, as a violation of community rights and a violation of the rights of nature. And further, these laws directly confront the key legal barriers to protection of the environment in our communities, the doctrines which continue to discriminate against democracy and against nature. This includes corporate rights, and thus these laws prohibit corporations, as well as higher levels of government, from overriding and preempting the rights of communities and nature. And critically, these laws empower nature and the people within their communities to enforce and defend their rights. And further, taking key lessons from the suffragists and other movements, communities that have enacted community rights and rights of nature laws are now reaching out to neighboring communities to help them learn about this and help them to replicate this change. And now they're gathering together within states to drive change from the grassroots upward to the state level, as we've discussed with the proposed constitutional amendments here in Ohio, and is also happening in places like Oregon and New Hampshire and other states. So this change that began in a handful of rural small communities in the United States has brought us to work in other communities as well. The Legal Defense Fund was invited to meet with the Constituent Assembly of Ecuador back in 2007 and in 2008 to discuss rights of nature constitutional provisions. We met with what they called mesas, or committees, that were tasked with drafting different parts of the Constitution. So we met with the mesa focused on environment, the mesa focused on development, and then they invited us to meet with the mesa focused on fundamental rights. So in 2008, Ecuador became the first country in the world to recognize the rights of nature in its constitution. As Tish said in introduction, I flew in from Ecuador yesterday, and I know I look fresh as a daisy. Is today the 29th of September? Okay. It was 10 years ago yesterday that the people of Ecuador ratified their constitution by a nationwide referendum. I was there in Quito to celebrate that, and over the past 2 days, there's been a Rights of Nature conference bringing people in from all parts of the world to celebrate this incredible achievement and talk about how the nature has built, how, not nature, but movement has built since then. And that's what I want to talk to you about today. So in their constitution in Ecuador, the rights of nature are now recognized as fundamental rights, just like the rights of people are recognized as fundamental rights. They created a new chapter in their constitution, Chapter 7, Article 71, the first article in that chapter. I wanted just to read from it briefly. It reads, quote, "Nature, or Pachamama, where life is reproduced and occurs, has the right to integral respect for its existence and for its maintenance and regeneration of its life cycles, structures, functions, and evolutionary processes. Further, that all persons, communities, peoples, and nations can call upon the public authorities to enforce the rights of nature." The first cases now, court cases, litigation, have been tried in Ecuador, with courts ruling to uphold the fundamental constitutional rights of nature, that is, affirming that these rights are in fact constitutional, and the necessity of government to consider the rights of nature in its decisions that impact the environment. The first case that was decided under this constitutional framework occurred in 2011. in which the rights of the Vilcabamba River were found to have been violated by government road construction. The river was itself the entity bringing the case to defend and enforce its own rights. And now there have been other cases that have been brought forward in Ecuador that have found that the rights of nature have been violated and that the actions of government and of corporations have to be resolved so that they can resolve these violations and become consistent with the rights of nature. Courts in Ecuador have found that the rights of nature, as they write it, are transversal. That is, that they affect other rights in the Constitution, and their rights of nature are also affected by other rights in the Constitution. Ecuador's Constitution has a human right to a healthy environment, has the human right to water, and understanding that those rights affect the rights of nature as well. Since 2008, with the ratification of Ecuador's Constitution, there has been a growing movement. Bolivia has a rights of the law of Mother Earth law in place. In 2010, Bolivia hosted the World Peoples Conference on Climate Change and the Rights of Mother Earth. As Tish mentioned, we were involved in drafting there the Universal Declaration on the Rights of Mother Earth, which was issued and came out of the conference. It's modeled on the Universal Declaration of Human Rights, and it's now been presented to the United Nations General Assembly for its consideration. And this is growing interest in the rights of nature around the world. So we've been to places like Nepal, where we're working to build a coalition of environmentalists, trekkers, mountaineers, and others in support of a Rights of Nature amendment to Nepal's constitution to specifically address climate change. With our country partners there, we've developed a right to climate framework to establish the right of the Himalaya to a healthy climate and the rights of the climate itself to be free from human-caused global warming pollution. This comes as studies find that the Himalaya, which are known as the world's third pole, the Himalaya today are the fastest warming mountain range on Earth. And what that means is that glaciers are melting, impacting people, water, species, ecosystems, everything. If you're familiar with Nepal's geography, it looks like this. The Himalaya are here, so everything literally is downstream. As one Sherpa told us when we met with him, quote, "The mountains are turning black with the disappearance of the ice and the snow." So today we're meeting with members of Parliament as we build support for amending the Constitution to recognize rights of nature, to recognize right of the Himalaya. In India, we've been working for a number of years with environmental groups, public health groups, faith groups, on a national law to recognize rights of the Ganga, what they call Mother Ganga, the Ganges River, and the right of the people of India to a healthy river ecosystem. We worked together to draft the National Ganga River Rights Act, which was presented to Prime Minister Modi's government last year for its consideration. This effort in India is being boosted by several decisions that have been decided by the High Court of Uttarakhand in the northern part of India. India has states just like we do, and they have a system, a judicial system. The High Court is basically their Supreme Court in a state. The High Court in Uttarakhand in 2017 ruled that the Ganga and Yamuna rivers, as well as glaciers and other ecosystems within that state, possess certain legal rights. The court determined that this change in legal status from being considered property to rights bearing, that it was necessary for these ecosystems in the Ganga River to have these rights to, quote, protect and conserve these critical ecosystems. As you may know, today 500 million people in India depend on the Ganga River. They consider it their holy river. Yet it's regulated under conventional environmental laws just like ours, and it's an ecosystem that is in severe decline from water withdrawals, from pollution, from agriculture, and other threats. The High Court said that the river's very existence is in question. So understanding this integral relationship between the people of India and the river, the slogan for the campaign to recognize rights of the Ganga is Ganga's rights are our rights. Further to the south, in Australia, this August, our partners launched a campaign to recognize rights of the Great Barrier Reef as the reef suffers from ocean warming and acidification and pollution. Together, we developed model template legislation to advance these rights at the grassroots through ordinances, at the state level through state-level legislation, and through a national constitutional amendment. We're also working in places like Colombia. In Colombia, the Supreme Court earlier this year, recognized rights of the Colombian Amazon region. It's suffering severe deforestation and climate change impacts are growing. This came as in 2016, 2 years earlier, decision by Colombia's highest court, their constitutional court, in which the court ruled that a river ecosystem, the Atrato River ecosystem, possesses rights to, quote, protection, conservation, maintenance, and restoration. This river ecosystem facing decades of mining, which are severely polluting and impacting the river ecosystem and the indigenous peoples who depend on that river and live in the river basin. The Constitutional Court wrote, and I wanted to read just from the decision for you. It wrote, quote, policies and legislation have emphasized access to economic use and exploitation to the detriment of the rights of the environment and of communities. It is the human population that is dependent on the natural world and not the opposite. And they, meaning we, must assume the consequences of their actions and omissions with nature. And interestingly, the court referred to past people's movements. It said, quote, it is a question of understanding this new socio-political reality with the aim of achieving a respectful transformation with the natural world and its environment, as has happened before with civil and political rights. The court added, quote, now is the time to begin taking the first steps to effectively protect the planet and its resources before it is too late. In the decision, the court ordered a number of steps to be taken to resolve these violations of the rights of nature and to restore the river basin. This includes establishing a joint guardianship for the Atrato River Basin. The guardians are designated by the court as representatives from the national central government and the indigenous people who are living there. So many have said that the recognition of the rights of nature is in many ways a codification of indigenous values. When we were working in Ecuador 10 years ago, indigenous delegates who were elected to the Constitutional Assembly, they told us that enshrining the rights of nature in the Constitution would strengthen their collective rights as indigenous peoples. Right here, closer to home, we've been working with tribal nations on the rights of nature. As Tish mentioned, in 2015, we began working with the Ho-Chunk Nation, a tribal nation based in Wisconsin. Now, they've been trying for a number of years to advance the rights of nature, and just 2 weeks ago, the Ho-Chunk General Council voted by over 85% in support of a Rights of Nature amendment to the tribal constitution. Importantly, the amendment prohibits all fossil fuel extraction and genetically engineered organisms as a violation of the legal rights of nature. I wanted to read to you the introduction to the amendment, which explains why it is needed. It reads, quote, the people of the Ho-Chunk Nation recognize that environmental laws, which regulate the use and exploitation of nature, are incapable of protecting Mother Earth. In the tradition of our nation's relationship with Mother Earth, from which we came and upon which we depend, we recognize that to protect nature, we must secure the highest protections for her through the recognition of rights in the nation's highest law, our Constitution. John Greendeer, the former president of the Ho-Chunk Nation, explained it to me this way, quote, the rights of nature is who we are, who we were, and who we will be. So now, after the General Council vote, steps are being taken by the tribal legislature and the tribal membership to finalize this amendment. And if it is ratified, the Ho-Chunk will become the first tribal nation in the United States to recognize the constitutional rights in tribal law. And of course, closer to home, right here in Ohio, we have the people of Toledo seeking to secure rights of Lake Erie. The Lake Erie Bill of Rights. Who's here from Toledo? The Lake Erie Bill of Rights would have recognized the right of the lake to be healthy and free from pollution that today is destroying the ecosystem and depriving, of course, surrounding communities of safe water. I say would have because last week the Ohio Supreme Court, in its infinite wisdom, says the man in the crown, in its infinite wisdom, the court blocked the lake. You want to come up? The court blocked the Lake Erie Bill of Rights from the November ballot. Of course, this is hardly the first time, in its infinite wisdom, the court has blocked the people of Ohio from exercising their democratic rights, discriminating against democracy. But I will also say we will one day recognize rights of the lake, because I fully expect the people of Toledo and of Ohio to continue to fight for these rights. This includes, in fact, just in the last few days, Toledans for Safe Water, who sponsored the initiative, filed a motion with the Ohio Supreme Court for it to reconsider its decision to kick the Lake Erie Bill of Rights off the ballot. It's this kind of persistence, this unwillingness to go home, this unwillingness to accept things as they are, that is the hallmark of successful people's movements. And it comes with an understanding that fundamental change doesn't just happen. We have to force it to happen. But, there's always a but. But we cannot do it alone. The success of movements comes when we join together, understanding that our different fights aren't so different after all. Thinking back to the 1800s, activists for women's rights and activists for abolition understood that the legalization of slavery and the legalization of the subordination of women, they stemmed from the same constitutional foundation. They had common cause. And so many participated in both movements. Today, as the communities that we work with, as we share a better understanding of the system of law, the community rights movement is beginning to expand beyond environmental issues to engage communities focused on things like homelessness, on worker protections, and other economic and social justice issues. And so I invite you today, as we're all here together, to think about commonalities, about how the system of law upholds a legal structure which protects and protects and insulates discrimination. Discrimination against communities, against nature, and also against workers, against the poor, against people. And so, in conclusion, you'll see, as Tish mentioned, that after the break, we have breakout sessions called community conversations. There's 5. There's the Sustainable Communities session, mine, focusing on how we can, or more to the point, can't, protect the environment under existing state and federal legal structures. There's a session titled Healthy Communities, focused on public health and how we can or cannot make achievements in addressing addiction and other issues under existing legal structures. The third session on fair communities, which will focus on worker and labor rights and how we can or perhaps cannot protect workers under existing legal structures. The Just Communities session, which will look at elections and money in politics and how the law affects our democratic rights. And lastly, the fifth session, the Safe Communities session, looking at political accountability, racial profiling, and other ways people and communities are made unsafe under today's laws and governing. These are 5 important sessions, and you have to choose one. So, I invite you not to attend the one you already know something about. The one that when you saw it on the agenda, you said, yes, that's the one for me. No, it's not. Instead, for all of us to learn about how these seemingly different issues, these different areas, share much in common, I invite you, I implore you, to go to the session that you know the least about. This means all of us. So Tish, I'm not going to go to my session. This means all of us, and I'm looking at everyone, getting out of our comfort zones. How about we get uncomfortable together? For that, my friends, is the pathway forward to change. Thank you.